first, 26-01. And before we begin with this, I would like to introduce our special attorney, Mr. Kyle Goulia, and he will give us further instructions.
Good afternoon, committee. Can you all hear me okay? Good. All right, so all of you are familiar with policy 101. You've now got a copy of it. Obviously, the council adopted this policy some time ago. Policy 101 is a unique policy. Essentially, as I read it, it's a policy where the council has set forth standards of conduct for elected officials to follow. And it sets forth a process for when there is a grievance as it relates to those standards of conduct not being followed allegedly by an elected official, a process for those grievances to be addressed. Essentially, what the city council decided was that this committee, the personnel committee, would receive those grievances and then decide what to do with them. Under the policy, what this committee does with them is somewhat simplistic at the end of the day. You review them, you determine whether you're going to take any further action. If you take further action, what is that action? That action essentially is one of two things: investigate and then dispose, or investigate and decide if there is a censure that is warranted. You don't have authority as a committee to do anything other than censure. This is not a Chapter 17 removal proceeding. This is not a situation where any sort of administrative charges have been filed under 17.16 of the statutes, wherein the council would take appropriate action to conduct a hearing and then decide after the conducting of that hearing whether removal is appropriate. Entirely different process, not germane to this. This is more, and I believe, simplistic in nature with regard to what you're supposed to do under policy 101.10. And so, as I see it, this committee has 4 different grievances in front of it. And they're listed in order based upon the one filed against Mr. Hoiland being first, Alderperson Hoiland being first, and then Alderperson Ames, Yager, and then against the mayor. And the committee can address them in order. And the first thing to decide, I would believe, is does the committee have jurisdiction over the issue? The second issue is, on the face of the complaint, does the committee wish to address and deal with the complaint? If the answers to those 2 questions are yes, then it gets to how do you wish to address it? Do you wish to investigate? And if you investigate, you have a lot of latitude there. You can simply base it on the information that you've been provided. You might undertake the receipt of further information. You might ask for people to present themselves to voluntarily present info. That would obviously occur at a subsequent meeting if that's the case. So a lot of this is in your hands just to decide how you wish to effectuate your policy. Do any of you have any questions for me? Yes?
I do. In light of the fact that you started your comments with explaining that this is a unique policy, in what way is this different? And would we consider changing it because of the uniqueness?
I want to keep you within the parameters of the open meetings notice that's here. So I'll simply preface my comment of it's unique in that there's not many other communities that have a policy like this. And again, this is a creature of the creation of the council. So,
Are there further questions? All right, then for our first, as I mentioned, 26-01, is there a motion?
Ma'am, I have a statement I'd like to make.
Oh.
It is not related to a
I
motion.
think we'll need a motion first before we open discussion. So could I have a motion, Cindy?
Yes, I would like to make a motion to investigate further the actions under 2601.
And is there a second? No second?
I second.
Okay, there is a motion and a second. All those in favor to move forward?
Discussion.
And then we would have, oh, okay.
Discussion.
First. I'm sorry.
I have a statement. Madam Chair, members, city leaders, and community members, thank you for being here. This is an important time in the history of City of Lake Geneva and City of Lake Geneva's City Council. I take ethical obligations seriously, which is precisely why I repeatedly ask for clarity regarding the specific law, ordinance, and policy allegedly violated. None were provided, and in my research, I did not find any laws, ordinances, or policies that were violated. My visit to Public Works on February 24th, which I readily admitted, lasted approximately 10 minutes. No city resources were used, no audio was recorded, no city vehicles were used, no production support was provided, no video footage was used. No operational disruption occurred, no campaign financial benefit resulted, and no taxpayer funds were spent. I've walked through Public Works facilities many times as an alderman and a 2-year member of the Public Works Committee. What concerns me more is the inconsistent application of Policy 101.10. I submitted documented complaints involving other elected officials, including direct confrontational conduct, campaign use of email, and campaign photos in City Hall. Those matters were treated very differently. This committee must decide whether it wants to apply standards fairly or selectively, if it even has the authority to do so. I was re-elected by District 3 voters on April 7th. Any effort to discipline an elected official should require clear statutory authority, objective evidence, and due process, not subjective interpretations or politically charged falsehoods. I will accept fair accountability where actual violations exist, but I will not accept unequal enforcement or weaponization of administrative processes. Questions for outside attorney for extraordinary matters. Number 1, what Wisconsin statute authorizes disciplinary action of a city alderman under these circumstances? Number 2, what exact city ordinance or policy language was violated? Number 3, what prior precedent exists in the City of Lake Geneva? Number 4, what were similar complaints involving other elected? Why were similar complaints involving other elected officials handled differently? And number 5, what objective harm occurred to taxpayers? All I ask is fairness, being equitable and true. Treat everybody the same. I took that pledge of civility before I first got elected 2 years ago. Civility, what does that mean? That means to act in a civil manner, to treat everybody with integrity, respect, even though I disagree with them. I've done that, I've tried to do that. For the past 2 years, I've experienced significant chaos, disruption, and dysfunction from my colleagues. Not all of them, but in many cases, I've received all kinds of adverse reactions. This is unacceptable. This puts a dark stain on the City of Lake Geneva and on this City Council. And I hope that my comments will prevail and make sense to my colleagues here, although I must say I did pen a recent article. It was talking about rubber stamp governance. And I failed to understand or appreciate that fairness will prevail, but I can always hope, and I think we'll find examples of that this afternoon. Thank you.
Thank you. Is there further discussion? Mary, Alderman Fesenmaier?
I have a clarification question of the attorney again. What is the exact process for the investigation? Because that's the motion before us.
First and foremost, I think it's fair for you folks to discuss what you think needs to be undertaken to gather sufficient information so that you can make a determination under the policy. You're a legislative body. Little reminder lesson, I mentioned earlier that we are in a republic to some of you, and within our republic we have our different branches. We have our executive branch and we have our legislative branch. And within this situation here, as a legislative body, you're given the authority from the council to investigate. I would say that if any investigation is conducted by this body itself through the receipt of further information at subsequent meetings, that would be within your authority. If you feel that there is a need for an outside investigator to be utilized, then I think you're going to need to go to the council to request authority for that purpose, as that would require the expenditure of more funds than what we're already spending.
So this is not necessarily something we could refer to law enforcement at the county level to investigate? I just want to know the parameters.
Could this body ask a law enforcement agency to devote the time and resources to it? You could. It would be entirely within their discretion whether they wish to devote the time and resources to it. Yep.
Which is true, is what we're doing. If we want to investigate further, we're using our staff time and money.
Or you're utilizing the folks up here, more so than anything, meaning the 5 of you. This body itself is the investigatory body, essentially.
Even though there are people involved in other complaints?
That's where it gets interesting.
Right.
Correct.
That's why I asked about
Yep.
another group.
Yep. Yeah, so if it was referred to an outside group, you could certainly ask. I would say, based on my experience, the likelihood is low to none. Generally, they don't want to get involved in political disputes. They want to look for matters where there is a significant public interest that's at stake as it relates to a violation of law.
Can it be sent directly to council for the final review as opposed to this committee because of the members that are involved in other incidences here?
You could ask, and the council could kick it back to you and say, do your job. Yep.
Madam Chair, is it possible to get answers to some of my questions? Or do you need further time to...
No, I can answer your questions. I thought they were rhetorical part of your statement, but I will answer them. Go with your first one.
Okay. What Wisconsin statute authorizes disciplinary action against a city alderman under these circumstances?
The city council has broad powers to police itself and to police the conduct of its members. It's inherent as part of the body. A city council has the ability to even do things like exercise its rights under the First Amendment to censure a body. This is generally well supported under the law. The general adage is that you want to at least provide the person with notice of what the allegation is against them. And then from a liberty interest concept, life, liberty, and property, everybody got that? Good. We're not depriving anybody of property here because this is not a removal proceeding. So this is not a 14th Amendment due process removal process. This is also not the deprivation of life because there is no execution that is occurring. This governmental body doesn't have the power to do that, so we're not dealing with that. So then we get to the liberty concept. In a liberty interest situation, generally the opportunity to be heard is what is afforded to the individual. Alderperson Hoiland, with your statement earlier, you were afforded the opportunity already to be heard on your statement, through your statement. Certainly, if the committee wished to afford you an additional opportunity, they could do so. So to answer your first question, it's inherent within this body under their broad powers that exist, and that would exist with pretty much any type of similar municipal legislative body. Second question?
Well, there's no specific ordinance or statute which would prohibit an alderman from entering a public works facility.
You're not going to find in the statutes language that would specifically prohibit that I'm aware of and have seen in Chapter 62 of Wisconsin statutes. As it relates, again, it goes back to the broad powers that are given to a council to set standards of expectations of its members. Next.
Yeah, what city ordinance or policy language was violated?
And I can't spell out to you what was violated and what wasn't. My role is not judge. My role is to advise this committee. And this committee has received information, and I think it's up to them to analyze the policy and to assess, did the conduct itself come into cause to violate the standards that are outlined in Policy 101. Based upon what this committee then decides, I can provide them with a legal opinion as it relates to their determinations.
So to clarify, an ordinance is law, and a policy is a guideline. And so ordinances prevail over policies. In the case of the Personnel Committee, last fall we adopted a new personnel policy ordinance. There is nothing in the current City of Lake Geneva policy manual or ordinance that spells out in the Personnel Committee description its duty or authorization to deal with elected officials. There's nothing in there. It only deals with employees of the city. And I read it, I reread it, I read it again. The city ordinance makes no, in the Personnel Committee description and language, makes no provision to address elected officials, only city staff, including the city administrator. So with that in mind, there was no city ordinance violated. There was a policy that I don't believe was violated. So that's why I asked the question. And I think I answered it myself.
Yeah. I
Number
don't know if
three.
you answered it, but
Well, that's my answer. That was that one. Number three, what prior precedent exists in Lake Geneva? My guess is there's no knowledge of anything like this, but I don't know. You probably wouldn't know either because
I'm unaware of any prior grievances being filed into this policy. You folks would know better than I would.
Right. Also, I find it interesting that I was informed when I developed and authored my complaints against the two alderwomen and the mayor that I had to follow a format. And I had to be named as the complainant. Now, I noticed in 26-01, I'm not quite sure if there's even a format there. I believe the complainant and the grievance is being filed by the city administrator. In my research of the city administrator's job description and of the ordinance for describing the city administrator, he has no authority to file a grievance or a complaint against an elected official. So that leads me to number 4. Why were similar complaints involving other elected officials handled differently? And I refer back to April of 2025. I filed complaints against 2 alderwomen. It took 6 weeks before I got a response, and that was because I had to reach out again and say, are you going to do anything? And it took 2 months before we had private meetings with each of the alderwomen. And this was about ethical misconduct in a public venue in which they made statements. And there are other things that have happened since that time. Decorum has not been upheld in city council meetings. And so here we are. So I guess I'm not expecting our special counsel to answer this, but similar complaints have not been treated in the same way. Number 5, what objective harm occurred to taxpayers? Is there any harms you can, in everything we've read, has there been a harm to taxpayers? 0. There was no taxpayer issue at all. So with that, frankly, I believe that if this committee wishes to pursue investigation. It's baseless and has no merit. And I reached out to the city administrator and the city attorney several times, and I said, you have the discretion to, you know, and especially I want to point out, this was during an election process in which I was running a dual campaign for mayor and re-election to my city alderman position. Not an easy thing to do. Running for two positions, running for one for mayor is a lot of work. I'm sure Mayor Krause could attest to that. Running for two is really, really hard. Now, it's legal in Wisconsin to run for multiple positions, so I chose to do that. I don't complain about that. But this was during an election process. This was a very sensitive time. I asked for discretion from the city administrator and the city attorney. They did not provide discretion. They did not allow this to proceed past the election and let the election process take its course. So I sit here and I say, I have a sense that there's a lot of inequity here. And I would urge the motioner and the second to withdraw their motions because there's nothing here.
Is there further discussion? Alderperson Fesenmaier?
I would like to know my options. So it was investigate, which is the motion, right? Another option was to dispose of, and I understand that's not the motion, but we could have or possibly dispose of it, the complaint, or censure. Can you tell me a little bit more about censure? What the effect is and what that involves?
Yeah, the general adage of a governmental body like a city council, again, a legislative body when it is policing its members, that body has the right to exercise its own First Amendment perspective. And the exercise of the First Amendment perspective may be to censure, to simply serve as what may be perceived as like a counseling or an admonishment of a member, i.e., for example, the council reminds alderperson so-and-so of policy 101 requirements and requests that alderperson so-and-so comport themselves to those policy standards going forward, to something that is a little bit more harshly worded, to something that is substantially more harshly worded, but in no way, shape, or form depriving that person of their office, in no way, shape, or form depriving that person of their ability to serve and vote on important city business.
A follow-up question. Can the censure also include, so setting aside an investigation, so not disposing of it, but keeping it kind of like in a hold position and warning the person that if this happens again, that complaint will be activated along with a new complaint?
The adage of holding it over their head seems to go against the policy, but the ability to say to the alderperson, we are issuing no finding on this particular issue here as to a violation. We do direct your attention to policy 101 and encourage your compliance with it just as we would encourage that of all elected officials. But you'd be disposing of the matter. Yeah.
So if an investigation were to take place, if we gave parameters to that, this body would have the ability to, or we would have to take that, is what you were saying. Is that correct?
Yeah, unless you want to go to the council and ask the council to retain someone for purposes of conducting the investigation and then reporting back to this body. The other alternative, like I said, would be is this body at a subsequent meeting decides that it wishes to request information from specific persons who have information germane and relevant to the allegations in whichever of the complaints you choose to have investigated in that framework. They would provide this information to the body. I would view it as being voluntarily provided by those individuals rather than as compelled of them. If you wish to go down the avenue of compulsion and issuance of subpoenas and all of that fun stuff, we can certainly entertain that possibility and all the legal quagmire that comes with it, but nonetheless, is certainly a plausible thought that comes into my head. Whether it occurs.
So I guess to follow up on that, just reviewing all of this information is a bit distressing because a lot of it is hearsay on all of this. And a lot of it is missing legitimate documentation or information to be able to move forward with any particular action, such as the video that was taken had been deleted, and that we don't have anything purposeful to go back to follow up other than what is being said on his behalf and what other people are saying that should not have been taking place, but we don't have the exact evidence because it has been deleted, which I have problems with. But then the other thing is moving forward and making the city pay more money to investigate, to ask for that documentation, that deleted quote-unquote video is something that I think the people here would need to determine whether it's important enough to move forward to ask for that video to be found, and whether it's important for the city to pay money to be able to find that footage to confirm what was done. So that's where I stand with this. I'm not quite sure what way to move forward because, again, I think all four contain a lot of hearsay and a lot of innuendo and a lot of falsehoods on everyone's parts. And I think the investigation would be worthwhile, but again, I'm just not sure how far to take that personally.
Madam Chair, I want to correct one thing about Alderman Yager. I have no idea if that video has been deleted. I've never seen it. My videographer, took it. I told him, I said, frankly, we did it on a cloudy, cold day, and a couple days later it was sunny and nice, and so we went to another site and found something similar, not public information, not public equipment. It was private equipment. And so I don't know if it was deleted, but if you've ever been involved in making a movie, when you make a movie, you have the final edition and everything else gets thrown away, I guess. I don't know. I have no idea whether my videographer still has it or not. So if you want to go down that road, again, I want to correct. I did not tell him to delete it. Like I say, I never saw it. And I didn't even know what it looks like. But we used another site for that set shot, and that's what we went with. If anybody would like to see my video, please go to my website, joelhoiland.com. I still have it up there, and you can
We
see
don't
it.
need to self-promote here. Thank you.
I'm not self-promoting.
All of the videos.
Okay. That's enough from everybody. Please, let's be civil. Thank you. Do you have a question, Cindy?
I just have a statement as
Okay,
concerning the
Yager,
video.
please.
I have 2 emails in the packet that indicate from Mr. Hoiland that in fact, and I'm quoting here from his email, all video footage has been deleted. And that has been in 2 or 3 of the different emails that were in the packet. That's why I referred to it as being deleted, because it came out of the emails directly from me.
Yes, Alderman Ames. I'm sorry, I believe she was first.
My concern is the employee who got the reprimand in their personal record. This should be taken out. and this person has been a long-time good employee of the city. And if this won't be taken out of his personnel file, then we can't just drop this. Because the employees are right for the employees and the staff.
I did in my correspondence with the city administrator indicate that this state statute, I'm sure our special counsel will give us the, state statute that clarifies that we are not in a position to identify a city employee. But I did specifically ask that this city employee not be reprimanded because this was totally incidental. What more can I say? Incidental. So I agree with Alderwoman Ames. This employee should not receive any admonition or record in the personnel file.
Yes, Alderman Fesenmaier.
Another question. 101.2 policy in here, it talks about all newly elected and returning city officials are provided with an orientation packet, which includes information generated by the league, as well as council member orientation publication created and distributed by the Lake Geneva City Clerk's Office. Was and has this orientation packet been distributed, as far as we know?
I believe so, it was to me.
And then another question I have is about a training provided, local government 101 training provided by the league within 1 month of assuming office. Have we distributed and had electeds do that training?
I would assume so. I know I completed it within 1 month. So I would assume everybody did. But I do not know that for a fact. How the rest did. Could I have some discussion on that? I can only tell you that I was given this packet personally, and I did complete the course within the first month.
Madam Chair,
Yes.
specifically, I believe it was starting in May through December, I believe, at each monthly personnel committee meeting, we went through every chapter of the municipal policy. And we evaluated each chapter and the language, and I prepared summaries and recommendations for city staff, particularly the city administrator, to pursue. With regard to 101.4 general standards, summary requires adherence to law, policies, and understanding of all applicable rules related to elected officials. Recommendations provide a policy roadmap summarizing each policy applies to elected officials, an updated digital manual with keyword search for faster reference. And in some of the others, it talked about, the overall recommendations for modernization were digitized ethical compliance, implement structured training, meaning annual ethics, cybersecurity, and open meeting law, clarify operational boundaries with council staff interaction policy, improve transparency through public conflict disclosures and recorded recusals, strengthen accountability via consistent enforcement of censure procedures and public reporting, and promote professionalism and civility through a formal code of meeting conduct. These are recommendations that I submitted to staff, and to my knowledge, we did have one workshop, so to speak, with the executive director of the League of Municipalities, Jerry Chain, I believe is his name. All he did was talk about parliamentary procedure. There was nothing that I recall about ethical conduct training. So we have not had anything as a city council dealing with ethical conduct, other than personally reading the municipal policy manual, and that's discretionary.
Did you take the class 101 from?
After spending over 3 decades in government affairs as a lobbyist, as a professional in government affairs, I think I know a little bit about government affairs, how federal, state, and local laws apply, and how governance works. So, did I take it? No. Could I probably teach it? Yes.
Some of the ethical questions you've asked about are in that class. I don't know. I don't know how many have taken it. I did. Did you take it?
Well, 2 years ago when we were elected, we had a completely different administration. Lacey was not our clerk at the time, we had a different clerk. So I don't remember if we took it because it was different at
Well, you had two options. Do you recall going to Madison? You could go to Madison or you could do it online.
no.
I chose, and if you did it online, you could do it over a period of days. You went to Madison, you did it in, I think it was a day or maybe two over.
I don't believe that was given to us by the previous clerk.
Okay. I wondered. Is there further discussion? Then there is a vote. Is there an amendment that you wanted to present to this?
No, but just to clarify, the motion is for this committee to investigate.
Yes, it is. For this committee to investigate.
Could we clarify what to investigate? Could be more clear about specific investigatory criteria.
Is there specific criteria?
I would encourage each of you to look at the grievance that was filed, the February 26th grievance. There's 4 components to it. The first is alleging that Alderperson Hoiland did not seek permission from either department head or the city administrator prior to the arrival to film in the city facility and use city assets. So that would be one aspect of the grievance. If that is within the scope of your investigation, then I think you need to discuss who do you need to receive information from and what do you think you need to receive as it relates to that matter. Second is you engaged a city employee during working hours without prior approval or notice from either the department head or the city administrator for the purpose of using them for your video. Same thing. Who do you believe you need information from and what information do you believe you would need? And then third, you had a city employee participate in political activity while on duty, which is a specific violation of our employee handbook, section 901.4.1 and city policy 102.4.8, and have subjected that employee to review for disciplinary action. I think that is more of a referring to the employee's conduct of what they engaged in, and is simply referring to a consequence of the employee's behavior associated with it, but nonetheless, you need to decide what is it that this body needs in order to make a determination as to whether Alderperson Hoiland violated policy 102.4.8. And then you have the fourth issue of you utilize city property that is not available for public use and used it for the purpose of political activity. Again, what information do you believe is needed from that, and who do you believe you need to speak with or receive information from, I should say.
So do we decide that tonight or the next meeting?
I think if you want to get this done in another meeting, or at least closer to done, discuss it right now. If you want this to go on for 2 more meetings, wait till the next meeting. So I think it's probably worth discussing since you're all here right now.
So would it be beneficial to go through these one by one and decide?
I think you make a determination as to who you want to hear from.
In each instance or overall?
I think you're only dealing with the 2601 Alderperson Hoiland right now.
Right.
And then we'll deal with the others as they come up later on in order.
But Alderman Yager, were you referring to each of these 4 points?
Yes.
I thought. So in each instance, did you want to decide who, where, whom you want to find information from?
That would be a discussion, not a motion, correct?
It's within your discussion right now.
Yes. Yes.
I think we need the employee, the department head, well, that's where I think everything lies, is with those two people.
And possibly the videographer.
Videographer. Because we haven't heard from the employee or the department head yet.
Would we need to have an HR rep for the employees who are concerned? And perhaps you would want to also add to your list Alderperson Hoiland and City Administrator DeAngelis.
An assistant administrator.
Absolutely, if it seems appropriate.
Covers everything that I would be interested in hearing.
This one does. So, I think it's a fair question.
Okay, then who is presumed to do these interviews?
This body would. You would ask the person to voluntarily participate, unless you're going to go down the subpoena path, which we can again pursue that as an option and see whether there's legal viability to it. There are specific instances where subpoena power may be warranted. I can't say specifically whether this is one of those. But the general adage that I would foresee within this personnel committee jurisdiction within your authority would be that the person shows up, you have questions, you may pose questions to the individual, perhaps they might provide a statement, and if there's follow-up information that they wish to provide at the meeting, they may provide it to you, and then you receive information from the next person. I don't see the need for it to be a thorough trial or anything to that effect. This is the opportunity to receive information so that you can make an educated policy-based determination, much like you do when you are acting as a governmental body in other means.
Special counsel, what is the privacy requirement for the employee? Because Wisconsin statute, my understanding is they are protected.
They're not. 19.36 subsection 10B is in void, prohibits the release of internal investigation records during the pendency of an internal investigation. 19.36 subsection 10D is in dog, prohibits the release of records that relate to what we call our staff management planning situations, i.e. performance evaluations, and other comments or ratings involving an employee's quality of performance. The Court of Appeals has indicated that a disciplinary document does not fall within that prohibition. And at the end of the day, the general adage amongst our courts is that the public has a strong interest in knowing about allegations of employee misconduct and how they are handled, and the public has a strong interest in knowing about disciplinary determinations of governmental entities. And so my general experience, at least through public records related issues, is that those records, if they are subject to public records request, are often released after affording the employee the opportunity to challenge the determination to release the records. Now that's if there's a public records request. Let's go to the next side of the aisle, which is take the public records out of it. This is simply a determination of, do they want to release the information? Many of you in the room here probably recollect the name Sheriff David Clark. Sheriff David Clark hopped on the radio station one day and blasted one of his deputies and noted that the deputy was under investigation for some unsavory conduct. The sheriff, I believe, the recollect was incorrect as to which type of unsavory conduct that was, but the court noted that that was within the First Amendment parameters of the sheriff to release that information. So at the end of the day, if this committee wants to hear from that employee, I think the committee has the right to hear about that. And if the information is requested by the committee to be received, the committee may choose to receive that information if it so chooses in closed session under 19.85 1C as in cat, and possibly 1F as in Frank, or it may choose to receive it in open session. It's up to the body. This is not an evidentiary hearing under 19.85 1B, so that doesn't come into play.
And if this committee wanted to subpoena anyone, can you give us the process and cost involved?
I'd want to dig into that further if that's a situation that we even need to go down.
Well,
Yeah.
Alderwoman Ames did name the videographer, so that is unlikely to require a subpoena.
And that's where I think that this body should decide what information do they think they can obtain from the videographer. Certainly, Mr. Hoiland, you might choose to have the videographer come if you think that it validates your position.
I have another question. Once the investigation, if this motion passes and we do an investigation, what are the parameters at that point? So are we back to disposing and/or censure? Those are our two options after investigation, or are there other options?
Generally, under this policy right here, you have the authority to review the matter, and you have the authority to censure, which means encompassed within that is the inherent power to dismiss.
Okay, any more questions?
Only a final comment. I think this body has an opportunity to take in what I said in my opening statement and all the questions that have been asked. And it is my belief, my heartfelt belief, that there's nothing here. You're going to expend city time and expenses pursuing something that is not warranted and that frankly will look ill on this body. So I'm asking that you decline to pursue this endeavor.
I do have a question. Is there an expense to our looking into the matter more thoroughly, as long as it's just this body and we're not asking for people that, from the outside, city personnel, the people on this committee, is there?
There's always an expense as it relates to time for yourselves. There's always an expense as it relates to the time and the energy of your administration, that every moment they spend in here is a moment they're not spending on other city business. And then there is the substantial cost that is associated with any legal fees associated with the matter itself.
Okay.
Yep, I'm happy to extrapolate further if I didn't answer your question.
Yes, Alderman Yager.
Just curious if you would need to be involved when the interviews happen.
You folks make that determination. You don't have to invite me. My job is to simply look out for the best interest of the city. And if you choose not to involve me, that's a client's choice to make. Well respected.
Yes, Alderman Fesenmaier.
So my concern and dilemma right now is the path forward. I don't want to assume, but one would likely assume that parties involved would have learned something from this process and be laboring the process using staff time. We know we're in the middle of trying to prepare for the Highway 50 construction along with strategic planning. There are very important things ahead of us, not to minimize this because I think it is important, but it can be dealt with in other ways. And censuring, I'm not sure that would do anything more than what we're actually doing right now. We have concerned citizens. I think the point has been made, at least in my mind, about civility, that the way forward is not whether we agree or disagree on items, but how we discuss those items.
I would agree. Yes, Alderman Yager.
So can I make an amendment to move it to censure as opposed to investigation?
Yes, you can make that amendment if you choose.
And that way, we can determine, and this is a question for Laura, we can determine what the censure would be as far as what needs to be done or what needs to be happened.
The body would discuss the censure, what the content would be, and then would come to some sort of determination where it would vote on what the censure would be.
Okay, so I would like to make the amendment to move the investigation to a censure.
I'll second.
Do we want to, are we ready to discuss, or want to discuss, or are we ready to take the vote?
I think we're ready to discuss.
Okay, yes.
I would
I'm
like
sorry.
our
They're all
special,
sitting there. I should have looked you in,
Thank
very
you.
sorry.
I would like our special counsel to enumerate what a censure means, what the impact is, how it's structured, and what happens beyond censure.
Under policy 101.10, the Personnel Committee has the authority to investigate grievances and, if deemed appropriate, issue a written public or private censure which will be placed in the personnel file created for the person who has violated the norms and protocols of elected officials. That's the specific verbiage. And so, if the Personnel Committee is satisfied with the information that it has received through all of the written documents it has, as well as the statements being presented this evening, including the information provided during discussion earlier, the committee may determine that that satisfies its investigation, and it may deem appropriate the authority to issue a written public or private censure. I'll cut to the chase on this one. Here in Wisconsin, we are a beacon of transparency, and so a private censure probably is not something that would not be discoverable, would likely be subject to release under a public records law. So whatever you do choose to do, you should do it with a lens of transparency. And the content of the censure would be the expression of the First Amendment rights of this body if it were to express approval, disapproval, neutrality as it relates to the conduct of the alderperson as alleged in the grievance and as you determine from the information that you reviewed. What's the effect of it? It's a letter. It's up to these people to decide what the effect is.
Thank you.
Yep. No financial deprivation or anything. We're not dealing with that. And as I mentioned for the third time, this is not a removal proceeding or anything to that effect.
So just to clarify, if it's a public one, then that gets printed in the paper and put out in a file for FOIA? No?
It's just a letter.
It's just a letter.
If it's public, you know, the difference between a public and a private censure, what I'm getting at is they're both going to be subject to release under a public records analysis after affording the subject of the record 5 business days and the opportunity to augment the release of the record under 19.356 of the statutes. But there's no affirmative obligation of this body to publicize anything.
Okay.
Madam Chair. What, I think the right word, what recourse would the person receiving a censure have if a censure is administered?
Do you want me to answer that?
Yes, please.
Fair question.
Yes.
I'll stress this by stating and reminding that my client is the entity here, not you, Alderperson Hoiland, individually. But any individual alderperson has a First Amendment right to speak their position. And certainly if they disagreed with the determination of this personnel committee, much like you might disagree with decisions that the committee engages in from time to time or the council engages in from time to time, you generally have a First Amendment right to vocalize your position on it.
Thank you.
And how does that occur? Where does that occur? When does that occur? If you voice your objection to the censure.
On the sidewalk, on social media, during public comment period, all of those areas. It would be fair game for an individual to do so. During a particular meeting, it would have to be something that would be agendized.
I see, okay.
If there was something that the alderperson felt that was so damaging to their reputation that it served to essentially ostracize them in the community and render them unemployable in their particular industry, you might afford that individual further opportunity to provide you with information during a committee meeting, but I don't think that anything that I'm seeing here would rise to that level of stigmatization.
So again, Madam Chair, I'm asking that censure not be administered, and that, again, the facts in this situation do not warrant any action, period.
Alderperson Fesenmaier?
Again, my concern is moving forward. We have strategic planning that we need to be unified behind. We have the Highway 50 project that we totally need to be unified behind. We are not. We have division in the community. We need to unify so that this goes well. We have other projects that we need to be unified. That doesn't mean we can't speak our minds or disagree on topics, but that means coming out of meetings, we need to be unified and not bullying. So it's the best way forward for our community to unify people that are divided in the community, that we provide a unified front, not a divided front, because we have another meeting at 6 o'clock. What will the attitude be then? That's my concern.
Have you fears that censure would, since it is essentially a letter, okay?
Right, yes, and we know that there have been past election results, let's say, that are still held over people, and that they are named specifically. I haven't done that personally, but there are other people that do. And I think that kind of behavior we need to leave in the past, and we need to act civil to each other, even when we disagree. Especially when we disagree.
In this, I am in total agreement. All right. I guess we're going to call the question. Would we like to individually? Okay. Roll call.
And can you just maybe restate the motion?
Oh, I'm sorry.
Yeah.
Yes, because it has been amended.
Yeah.
Yes, could you
The amendment was to,
maybe restate the original question?
the original motion
And then
was
amend
to
it.
investigate further, and then there was an amendment to move to censure. All right. Cindy Yager,
Yes.
Sherri Ames,
Yes,
Mayor Jo Fesenmaier,
No.
Joel Hoiland,
No.
Janelle Powers.
Am I allowed to make a small statement? No, right, I guess. I am obviously very torn by this because an employee has been censured and I don't like that. It seems disrespectful to say that it's all right for one and not for another. This is distressing. Yes.
Terrible. You guys. We don't have unlimited funds, you guys. Just keep spending money. Yep. Yeah. No.
All right, as it relates to this censure, the body needs to decide right now what it wants to do. Okay?
I believe including all of the documents that were in our packet and a letter that is created by this body to indicate what we believe was done improperly be put in his file.
Is there anything else? Any other discussion?
Is it fair that the committee wants at the next meeting for the chairperson to bring back a packet of documents with a cover letter to go with it for the body to take any further action on?
Okay. If that is the decision. All right, so that will be the decision of this committee to bring forward the information that was included in the packet, no further investigation, and with a letter, and that will be the end of this discussion. Okay.
No, it won't. No, it won't be last.
Okay. We'll move forward to 26-02.
Madam Chair,
Yes.
I move to investigate Alderwoman Sherri Ames for misconduct as pertains to, and as clarified in my complaint. And I am the complainant. I have 3 complaints, and I don't know if we should bring each one separately or bring them collectively. I would seek special counsel for direction. They are 3 different dates.
From the body standpoint, they're treated as all-encompassing one. They are 3 different complaints subset within one grievance. And so grievance is the overarching concept, and then 3 complaints within the grievance itself.
So I have moved to file an investigation into all 3, and specifically complaint number 2, which occurred on March 18th, 2026 at Horticultural Hall in Lake Geneva. And I would ask for a second.
Can I just get clarity on the motion? Are you asking for them to investigate the grievance as a whole?
Yes.
All 3 complaints?
All 3.
Okay,
Yes.
just because you separated out the second one there.
I just want to be sure that that was clear. Thank you.
Okay, a motion has been made. Is there a second?
Oh my God.
And this will,
Oh,
this will be indicative of the process
Get him, Hoiland.
and the severity of these complaints.
Well, seeing no second, the motion fails. Is there another motion? Okay, Alderman Yager.
I'd like to make a motion to dismiss.
All right. Is there a second to this motion?
Well,
Well,
I'll make a second, you know these people will not be happy about it.
Okay.
Okay, second.
All right, there is a second
Discuss
to the motion, so it is open for discussion.
Okay, I'd like to speak, please.
Absolutely.
So I did not come about these, well, I raised my hand first.
I made a motion, I get the right to speak first,
Excuse me, you are absolutely correct.
according to the rules.
According to Robert's rules, yes.
So, again, I bring up the same topic that I said with Alder Hoiland, is the fact that there is not refutable evidence either way as far as what was going on. It's hearsay, and I don't believe that it needs to be moved over.
Okay, thank you.
Yes.
I seriously contest that statement because there's video evidence in complaint number 1. All we have to do is go back to the recorded video of that meeting and you will hear specifically what Alderwoman Ames stated. In her remarks, Alderwoman Ames referenced the length of time elected officials have lived in the community as a basis for credibility and decision-making authority. Implicitly and explicitly distinguished certain aldermen, meaning Alderman Hoiland and Alderman Smith, as less qualified or less legitimate based on their shorter residency. She stated that some individuals in the community questioned, where do these people come from? This is a quote. It's on video. You can't tell me that that doesn't exist. Further suggested that certain aldermen were attempting to change our community to benefit them because they didn't like where they came from.
Wow.
Okay, that was complaint number 1. Now, complaint number 2 on March 18th. And Mayor Krause and I were in a mayoral forum, not a debate, but a forum. At the conclusion of this, well, I should say, during the mayoral debate, or correct myself, forum, in the front row sat Alderwoman Ames and Alderwoman Yager, both of them acting in an inappropriate manner. At the conclusion, and I would say that this was probably one of the largest turnouts for a mayoral forum that I've seen in the last 5 or 6 years. I'm standing up collecting my things, and Alderwoman Ames approached in an aggressive and confrontational manner, positioning herself directly in front of me and physically impeding my ability to disengage. She called me a liar and made escalating verbal accusations. When I stated I did not wish to engage and attempted to sidestep away, she continued to block my movement, resulting in a minor physical bump. Immediately thereafter, she loudly stated, "He hit me," creating a public accusation. A false police report was filed, and a City of Lake Geneva police officer subsequently came to my residence and initiated follow-up questioning, escalating the matter into a formal complaint process. No context? 2 sets of police cams, in which she made comments about the incident, the initial police report, and the second interview on her front porch that were made public, further demonstrate intentional misconduct to berate, demean, and purposely damage the integrity of an elected official. And this is serious, serious accusations. These are serious actions. Additionally, Alderwoman Ames disregarded forum organizer guidance prohibiting campaign material by wearing a campaign t-shirt, black t-shirt with white lettering, "Elect Krause Mayor," inside the venue, in the first row. So I've outlined all policy violations, the basis for the violations, the behavior of how it undermines our professional governance standards, our public confidence in elected officials, safe and respectful interaction among council members. And I'm requesting formal review by the Personnel Committee, which we are doing right now, determination of policy 101 violations, and frankly, censure is not even enough. I think this needs to be investigated, and it's embarrassing that Alderwoman Ames, you would move to dismiss with these. And I have witnesses who will document and come forward readily and willingly to document what they saw. They may not have heard, but they saw exactly what happened. So this is a tremendous injustice if you proceed not to pursue this action. And finally, the third one. On April 15th, 2025, at the Finance Licensing Regulation meeting, Alderwoman Ames and Yager made comments. Alderman Ames publicly supported and expanded, while discussing a proposal related to parking accommodation for food pantry volunteers, Alderwoman Ames made a public statement accusing me of violating city policy by allegedly directing city staff. Ames publicly supported and expanded upon allegations made by Alderwoman Yager that Alderman Hoiland, me, had improperly contacted and directed a city employee. She stated that she had been told not to contact staff directly and asserted what's good for one is good for everybody. Again, there is video documentation that I can give you the exact timestamp on that. She went beyond everyone, he said, you went beyond everyone's back on this. She made these remarks in open session in a pointed, accusatory tone and without prior inquiry or verification of the facts. When Alderman Hoiland attempted to respond, Ames interrupted and asserted control of the floor because she was the chair, continuing her remarks before allowing a response. So that ended up, I filed a complaint on, I believe it was April 21st, 2025. I sent it to the city administrator, the city attorney, and the mayor. And I did not receive a response until I followed up, I believe it was June 6th or thereabouts, when I went back and I said, are you going to do anything about this? And at that point, we then began a process. And at that point, so much time had passed. What I decided to do was to have individual sessions with each of them. And we did so on June 21st. June 21st. Remember, the incident took place on April 15th. So you can understand my surprise at how the city administrator jumped on my situation within a day or so of that happening. And he waited 6 weeks before he even responded to me on my complaint. So here we are. I've got 3 complaints. One of them particularly is maybe a criminal violation, filing a false police report. That's a serious matter. The other 2, I think, are ethical misconduct complaints. And so, again, I assert that to dismiss this would be you will find that the community will not be pleased with this development. I suspect that if you do not pursue some type of investigation and actually get the documentation that goes with these, you are allowing injustice to prevail.
I have a question. The police report, was it deemed fake? Was it deemed false?
There were 3, if I could answer you. Nancy Douglas from the radio station, 96.1, did a public records request and to the police department. And they released 3 police cams. One was Alderwoman Ames' initial police report. The second one was the police officer coming to me for my statement. And the third one was back to Alderwoman Ames after I had given my statement. And so those 3 police cams were released to Nancy Douglas. She then posted them on Facebook. So they are a public record.
But my question was really, was it deemed by the police a false report?
I filed a false police report. I filed a false police, put it this way. I filed a police report that it was false.
Okay, so you filed a counter report with the police saying that you felt the allegation was...
It was a false police report.
Okay, but what has been the decision on yours and Alderman Ames, have the police decided it's been a false report?
The
Have they
police chief
deemed you
referred
correct?
all complaints to the county sheriff.
And what was his decision on that?
We have not pursued that at this point.
Okay, so we cannot verify that it was or was not a fake report, a false
Well,
report.
if I filed a false police report, that is a claim.
Oh, it is your claim, yes.
Yes.
And so we don't know yet whether the authorities have decided that you were correct or that
Well, that would not be
Alderperson Ames was
the role of law enforcement. That would be the role of the judiciary to determine that. And I would ask special counsel to confirm that.
Law enforcement agency can refer the matter to charges to the prosecuting authority. It's up to the prosecutor to decide whether there's anything they wish to go on that. What I want to clear up is, it sounds like as of right now, no determination has been made as it relates to any charging decision and thus any prosecutorial decision. Correct. Yep.
Yes.
I'm going to start with that one first. Alderman Hoiland and I agreed to drop the charges against each other. This is the first I've heard that this has not been dropped. We both were in the wrong that night. I walked up to him and I did tell him he said some lies. He said to me, "Get out of my way," and he pushed me. I should not have pushed him back.
Okay,
Okay? So that was the end of that till I went down to the police station, told them what happened. They did not go to Alderman Hoiland's home to talk to him. They went to, it's on the video, unless your home looks like Tuscan.
My wife can confirm that the police officer ended up at my home, knocked on our home door.
Where did they, the discussion is, where did they interview you at? It wasn't at your home, it was at Tuscan with a group of people. That were there.
please.
But to my knowledge, we both agreed afterwards that we both would drop the charges. This is news to me. Officer Keller is here, Lieutenant Keller is here. And that's what was decided. This is news to me. Yes, I had a t-shirt on, but there was nowhere in their literature that they put out that you could not wear t-shirts. There was a sign that said no literature could be out. And I also had a sweater on. I sat in the front row. I had a constituent sitting next to me. He was taking notes, and him and I were discussing things that were going on. Alderman Yager, there was a person between us, another constituent. So we never even talked. You know, if you want to continue this and file charges against me, I can file charges against you also for pushing me. But I should not have pushed you back. About people saying that I had a lot of people in this community say to me, where do these people come from and why do they get involved when they don't know our community? And there's some people sitting out here.
This is communist China.
Excuse me.
Please.
What's the time limit? 5 years before we can even call?
This is from people who have lived here for many years. I have the right of freedom of speech, just like everybody else does. And for some reason, it's good for thee, but not for me. You know, the other thing is, I could have done grievances against Alderman Hoiland also, but I felt it was a waste of staff's time. I'd like to know how many hours staff has wasted time on grievances that Alderman Hoiland has done against Alderman Yager and myself. This is costing you taxpayers money. You know, he's just as guilty on talking down to us as we are to him. But that's okay. That's okay. Oh, about the parking for the food pantry. One of the things, we are not to go to staff and tell them what they're supposed to do. This is a nothing burger on that one. This was just to give the people who are volunteering at the food pantry a few hours a week to be able to park and not get a ticket. Because a lot of these people who work at the food pantry don't have a parking sticker. They come in from all over to help the community. And if we can't give them a few hours, and it's on a Wednesday, it's not on the weekends. Let's just put it that way. It's not on the weekends. And it's at a part of town where people are parking during the week.
I fear that we are running out of time, unfortunately. There is another meeting that occurs here in, yes, approximately 5 minutes. So, as loath as I am to say we need to adjourn, I fear that we're going to have to table this until the next meeting.
We should have tabled it before we started.
Probably,
Yeah.
but that didn't occur, so here we are now. Is there a motion to adjourn? Oh, yes, first I have to continue, excuse me.
Madam Chair,
Yes,
I've been part of several committees that extended beyond the time limit and approached actually the common council meeting, public works specifically. And, we continued sometimes until 6:30 when the common council was set to start at 6 o'clock. Not frequently, but it has happened. And it has happened within the last year or two. So I would say perhaps what we should do is complete 26-02 now, so that we can then perhaps continue 2603 and 2604 I would suggest a special meeting, not the next meeting, because that's all the way to June. So I would request a special meeting in a short time frame.
I would agree that we should probably continue with 2602, but I don't want to make it a policy that we go beyond the 2602, and a special meeting I don't believe is called for. We can continue this until June, but I would need a motion on that. We have to first satisfy the motion to dismiss. I think we should take roll call.
Okay, the motion on the floor for 2602 is to dismiss. Cindy Yager.
Yes.
Sherri Ames.
Yes?
Mayor Jo Fesenmaier.
Yes.
Joel Hoiland.
No.
Janelle Powers.
Yes.
Motion carried.
Okay.
A special meeting. Joel Hoiland.
Yes.
Mayor Jo Fesenmaier.
Yes.
Sherri Ames.
No.
Janelle Powers.
Yes.
Cindy Yager.
No.
Motion carried.
We will set a special meeting. I'll make that announcement when I review